Hi, everybody. I've got 6 o'clock right now, but I'm still going to give people just a couple minutes to come in. Based on those that are in and those who are SVP'd, I think we've got a few more that'll be joining.
Well, there's just a few of us, Matt. I'd like to thank you for doing this for us.
Oh, no problem. I hope you get a lot out of it.
I think we will.
If you don't like it, don't tell me.
I won't.
All right, I'll probably give it one more minute.
And hopefully it's more informative and entertaining than the governor's State of the State address.
I did not watch that. I'm sorry. So I don't know how.
No, that's going to be coming on at 7 p.m.
Oh, okay. Well, I will. I don't know. I mean, I can go longer if you want to say you couldn't watch this, or I can go shorter if you want to be sure to be able to see it. I'll probably I anticipate being done inside of an hour. So if I don't know if that helps you or hurts you. All right, I'll do a little bit of introductions and kind of get started. First, thank you all for joining. My name is Matt Heron. I'm an attorney here at Hirzel Law. I specialize in community association law, as all of us do here, but also document amendments, opinions. And one of the things that I do here is I serve on the Legislative Action Committee for the Community Associations Institute Michigan chapter. And so as a part of that, I try to monitor and keep up to date as to the different bills and acts that are both pending in the Michigan legislature and also in Congress, and then also those things that pass. And so I did something similar last year, but the goal of this is to try to educate those that are on and give you some information about what happened in the last legislative session last year, and then also give you an idea about what didn't work out, what things didn't pass or what failed, and what things could be coming down the line in the future. So what I've done is I've tried to break it out into 4 different categories. So there's 4 different things I'm going to be talking about. I'm going to first touch base on the federal level, the different federal initiatives that exist that you should at least be in tune to. There's nothing immediately pressing here, but these are things that have been introduced or we expect to at least come out in different forms, potentially in 2023. The next thing that I intend to talk about are those at the state level, those community association oriented bills that passed and were actually turned into laws in the state of Michigan in 2022. And there are 4 of them. The Protective Restricted Covenants Act, an amendment to the Marketable Record Title Act, amendments to the Summer Resort Act, and then a new Uniform Assignment of Rents Act. On top of bills that passed and that were enacted into law, I'll also be talking about a few bills that were kind of hot items in 21 and 22, but did not pass. So there were several bills that were introduced that were of potential significance to community associations, but didn't pass, and we may see down the line. And these 4 bills, or the categories of these 4 bills, they deal with short-term rentals, really at the municipal level, but potentially implicating or impacting community associations. A construction payment and prompt payment for subcontractors bill. This is actually 2 bills. I only wanted to touch on it, and I'll get to it later on, but to at least let you know the types of things that get introduced, which often don't go anywhere. A condominium accounting bill, similar to the Construction Payment Act bill. This was introduced and didn't go anywhere, but I do want to touch on it. And then there was another effort made for additional certifications for emotional support animals and to regulate that. And then there are a couple bills that we expect to come up, or we're working on at the LAC with respect to fines, liens, and assessments, Marketable Record Title Act, and then dealing with reserve studies and building inspections, which is not just at the state level, but at a federal level. I do see, Steve, you've got your hand up. I see that. If it's, I'll take a crack. I haven't started, so go ahead, ask your question, but other than that, I'll probably wait till the end to answer questions.
No, my question is, are you going to be sending out your presentation, or what kind of notes do we need to take for what you're going to be
We can
discussing?
make it available. If you would like a copy of it, we can make it available in PowerPoint. That'd be fine. It may be a PDF that goes out. This presentation itself will also be saved to our firm's YouTube page. And so you'll be able to enjoy the soothing sound of my voice for all eternity if you really want to do that. Enjoy yourself to sleep. But
Thank
they'll
you,
be available.
appreciate it.
Yep. Okay, so first up, with respect to federal initiatives, the first thing I wanted to touch base on is updates or changes, potential changes to the Fannie Mae and Freddie Mac lender questionnaires. In June of 2021 was the Surfside condo collapse. And coming out of that, Fannie Mae and Freddie Mac both issued bulletins which updated the information required to be contained in their condominium questionnaires. And they took very similar positions. From Fannie Mae had indicated that loans that were secured by units within condos that required significant deferred maintenance or had been determined to be to have unsafe conditions due to a need for repairs were deemed not eligible for purchase, which meant that the market for lenders was going to be decreased in condominiums with those issues. Similarly, Freddie Mac came out with their own bulletin and indicated that effective February of 2022, mortgages secured by units and needed critical repairs, which was their terminology, were similar to Fannie Mae, not eligible for sale to Freddie Mac. What this meant was that with Fannie Mae and Freddie Mac being the largest guarantors or purchasers of mortgage financing in the United States, that could potentially limit the market of people capable of purchasing units in condominiums that either had significant deferred maintenance or critical repairs. In order to make these assessments, both Fannie Mae and Freddie Mac use lender questionnaires in order to determine whether or not these the condominium projects themselves meet the above requirements and other qualifications. However, these questionnaires pose some difficulty. In practice, throughout 2022, condominiums, property managers, and lenders found these questionnaires to be cumbersome and difficult to complete. They were somewhat confusing, and there were often questions posed or presented to associations with respect to the potential liability if they answered these questionnaires incorrectly and there were later problems with the loan or with the condominium itself. As a result of these issues, in October of 2022, Representative Gooden from Texas wrote to the Federal Housing Finance Agency expressing these concerns, basically over the questionnaire over the rules that had been adopted by Fannie Mae and Freddie Mac. In response, the FHFA director had responded to Gooden, acknowledging that these new rules have caused confusion in the condominium markets and indicated that changes are in works. Quotations from her letter specifically states that they are working together, basically the FHFA and Fannie and Freddie, they are working together to enhance and clarify questions aimed at reducing confusion and liability concerns in 2023. So the major takeaway from this particular issue is that at least at the federal level, we do expect to see potential changes to the lender questionnaires, ideally simplifying the lender questionnaires sometime in 2023. The request has been made to the FHFA to do that. They've acknowledged the need for those changes, and so we'll see what happens. As of yet, at least towards the end of January, we haven't yet seen any changes, but that's something that we do expect to see in 2023. With respect to bills, so with respect to bills that have been introduced in Congress, there are three that are worth discussing. None of these three passed, so not all of these died at the end of last session of Congress, but these are expected to be reintroduced in some capacity and at least addressed in some capacity. And I'll kind of get into why in a second. But each of these three bills do three different things. And each of these three come out of the Surfside condo collapse that occurred in 2021. The Safer Condos Act, which is the first one, HR 7532, this is from the perspective of the owner, from the co-owner. The purpose of this bill was to attempt to try to make it easier for condominium owners who face special assessments to finance necessary building repairs, to allow them to roll those special assessments into existing mortgage debt in an effort to try to make it easier for them to repay and pay the special assessment, ideally making it easier for the association to collect those special assessments when needed and make those repairs. The second bill, which was HR 8304, Rapid Financing for Critical Condo Repairs Act, this was at the association level. This was intended to expand an association's access to private financing and private lending for building rehabilitation loans. As you can probably tell, both of these bills are really directed towards communities and condominiums that have a significant need for repair. Again, it's intended to try to avoid issues that occur with Surfside and make it easier for communities to raise the funds necessary to be able to maintain their buildings. The last one worth mentioning in this slide, at least, is something called Disaster Assistance Equity Act, HR 5298. This is a little bit of an oddity to a certain extent, but basically this would expanded FEMA's public assistance program to include communities with private roads. Currently, communities with private roads and waterways technically aren't eligible in many ways for FEMA's public assistance. And so this would have expanded that to allow even those communities with private roads to get access to FEMA's public assistance program. None of these three passed, but at least from the perspective at the national level, the goal is to try to continue to educate legislatures about the need for repair and then build on that going into the 23-24 session. All right, at the state level. So what passed at the in the state of Michigan that's relevant to communities in Michigan? So the first one that we wanted to address, because it specifically deals with communities in Michigan, is something called the Protective Restrictive Covenants Act, 2022 PA 234. I checked to see if this had an MCL site yet. I wasn't able to find it. So I don't think that it's been assigned an MCL site, but it should in the near future. Basically what this does is this is part of an effort that's nationwide. I mean, there are a lot of states that are trying to introduce legislation like this, but it's intended to address the impact and effect of discriminatory terms and discriminatory provisions contained in deed restrictions and other declarations. What it does is, notwithstanding the amendment method that may be contained in governing documents, but it creates an obligation and a power of a board to remove, by filing a certain discharge document, by filing a discharge in the Register of Deeds, that would remove language that on its face is discriminatory on the basis of race, color, religion, sex, familial status, national origin, or other class protected by the Fair Housing Act, the Federal Fair Housing Act, Title 8, the Civil Rights Act of 1968. So what this does is it's intended to provide a vehicle to allow residents and boards to try to remove from their deed restrictions language that could be construed as that is on its face discriminatory. Even in the state of Michigan, if you look at deed restrictions from the 30s and 40s, there are older restrictions that contain the type of discriminatory language that is intended to be addressed by this. Included with that, with the act, is proposed language, so a kind of a template form that could be used. I've quoted it, or at least included a, you can see it at the bottom. But if you do have a situation like this come up in your community, you'll want to work with your property manager. If you're on the board, work with your property manager or attorney to figure out how to effectively remove the discriminatory provisions. But that's something that's new. It's considered a success because of its potential positive impact. And we expect to see others like that in other states. Also at the state level is an amendment to the Marketable Record Title Act. Some of you may recall that in the lame duck session of the 2018 session of the Michigan legislature, there was an amendment to the Marketable Record Title Act. Based on this 2018 amendment, there are concerns that persons with interest in the land of others, whether it's in a deed restriction, whether it is in some other form, whether it's a claim of interest, but they may be required to file a new claim of interest in the Register of Deeds to preserve that interest, or under the 2018 amendments, that interest, including use restrictions or building restrictions, could potentially be extinguished by the MRTA. Because of concerns about the potential impact of the 2018 amendments on communities in the state of Michigan and on other interested parties in the state of Michigan, the deadline to comply with certain obligations under the 2018 amendments has been extended to March of 2024. In large part, that's part of an effort to try to fix any issues that can come out of it. Now, on the LAC, we've been trying to get language into the MRTA with respect to community associations specifically, both at the condominium level and at the HOA level, meaning if you are in a community that's a subdivision or subject to deed restrictions, but not in a condominium. So far, we have not been successful in getting that specific language in, but in 2022, HB 6370 was introduced and passed. HB 6370 was initially drafted and introduced in order to address concerns by utility companies and conservation easement holders that the 2018 amendments could inadvertently strip those interests from the land. Basically, it could inadvertently eliminate utility easements and conservation easements that otherwise were intended to go into perpetuity. As a result, this amendment came into place, and it does specifically reference that it's intended to protect utility and conservation restrictions. At the same time, however, there is potential language, or there is language in this in the 2022 amendments that could potentially help community associations faced with MRTA issues. And specifically, there is language in this amendment that states that the MRTA, the Marketable Record Title Act, cannot, quote, bar or extinguish any land or resource use restriction. And then it gives examples, end quote. So the concept here is that this amendment passed. It does not specifically protect community associations, but there is language in here that could potentially be used by community associations if they are going to be affected by the 2018 amendments. So if you are in a community that is close to 40 years or older than 40 years, then this particular language could potentially be of benefit to you if it comes to pass that you have owners who seek to use the MRTA against your deed restrictions. Now, we do recommend that if you are close to 40 years, that you record a claim of interest that is contemplated by the 2018 amendment in order to prevent it from applying. But notwithstanding that, this language does exist in the new bill, in the new act, and so we'll see how that pans out. But it could be positive down the line. The next bill that I wanted to address is an amendment to the Summer Resort Act. This is relatively minor to a certain extent because it doesn't make any substantive changes to the Summer Resort Act. I don't know if anybody on the call is a part of a Summer Resort Association, but there are a couple of different acts that pertain to summer resort associations. But there was an act that was passed in 2022 PA 20. What this attempted to do, or what it did do, was it updated the amounts that are contained in the act to try to bring the numbers that are in there up to today's dollars. Depending upon the act that you're looking at, the Summer Resort Act goes back over 100 years at times, and so the dollar amounts that were contained in each of the acts, go back a long ways. And so the legislature saw fit to try and update the acts to adjust them for inflation in order to modernize those acts. So it probably doesn't affect a lot of people on this call, but it is something that the legislature did to try to at least bring these acts into the current age. The last one I wanted to talk about that deals with bills that passed is something called the Uniform Assignment of Rents Act, 2022 PA 115. So this is based on a model law. It's a uniform law. So you'll see laws like this in other states already. As drafted, this bill is not intended to address community associations. It's not intended to address condominiums. It's not intended to address homeowner associations. What it's intended to do is it's intended to encompass commercial situations where you may have a lender who lends to a landlord, maybe across several properties, and that landlord owns property and they have a tenant. And if that landlord, that commercial landlord, defaults on the financing agreement or the loan agreement or the mortgage that they have with their lender, then an assignment of rents gives that lender the ability to go directly to the tenant and say, your landlord is in default of their obligation to me. I have the right to collect rent from you. Pay me, the lender, instead of your landlord, whatever you're due for rent, which would satisfy the tenant's obligation to the landlord and would allow the lender to pay down the debt owed by the landlord. It is most often applied in commercial loans in a commercial setting. However, there is a similar concept that exists in the Michigan Condominium Act. Under Section 112, 559.2125 of the Condominium Act, there's a rent diversion provision which gives statutory authority to boards if you have a co-owner who is not paying their assessments. So in a condominium setting, if a co-owner is not paying assessments that they're supposed to pay, under Section 112 sub 5, the condominium association can go directly to the tenant and say, your landlord, our co-owner, is in default of their obligation to pay us assessments. Instead of paying your landlord, pay us the rent that you owe, and that will pay down the assessment obligation, and that will satisfy your rental obligation. That is a statutory rent diversion concept that is different than a contractual assignment of rents. And so we don't expect that the Uniform Assignment of Rent Act will be construed to apply to the statutory rent diversion under the Condominium Act. However, Sections 9 and 10 of the Act, of the Uniform Assignment of Rents Act, do contain certain provisions regarding the types of language it wants to see in a notice. And so the takeaway here is that if you are a board or a property manager that deals with or sometimes engages in enforcement of the rent diversion authority that you have under the Act, you may want to review Sections 9 and 10 and see what types of things the Uniform Act is requiring to be contained. So if there is a challenge at a later date, you'll be able to, whether you call it belt and suspenders or a cautionary approach, you comply with the notice provisions that are required by the Uniform Act. So this did pass. We don't think that it was intended to directly apply to condominium associations because it's instead intended to be directed towards commercial settings, but it's probably a good idea to be aware of it and at least take a look at the notices that are the notice requirements that are contained in Section 9 of the Act. So those are the bills that passed. Those are the at least with respect to what came out of the 2022 session, those are the 4 bills that and acts that I thought were worth mentioning and discussing because of their potential and sometimes direct applicability to community associations. I would now want to talk about some things that did not pass, what did not make it out of the legislature that I expect to see again. First up is short-term rentals. This came about in a number of ways. There are a number of different bills that were introduced that in some capacity dealt with short-term rentals. At least my view of it was that the one that was most likely to succeed was this HB 4722. It did not end up passing, but it seemed to have fairly broad support. And it's really opposed by municipalities, but it was a little bit surprising to me that it didn't pass. I think we may, depending upon the tolerance of the legislature and the aggressiveness with which it's pursued. We may see something like it in the 23-24 session, but we'll see what happens. But there are a couple things that I wanted to go over on it. First, this bill purported to say that for purposes of zoning, from the perspective of a municipality, the rental of a dwelling, including any short-term rental, was by definition a residential use of property and was a permitted use in all residential zoning districts and should not be considered a commercial use of the property. So from the municipality standpoint, if it were adopted, this would have significantly impacted the municipality's ability to zone or regulate short-term rentals in their community, which is why you can understand that it was opposed. Now, I'm addressing it because even though it has no direct impact on community associations, we can see it again in 23-24. And most significantly, it doesn't take that much of a leap to say, or at least for somebody to argue, that what is true in the zoning context and what is true in the municipal context should also be true in the residential world of community associations. And so if this were to pass, I don't think it's too much of a leap for at least some individuals who could be proponents of short-term rentals to take the position that the language of the act, depending upon how it eventually comes out, or the language of the bill, excuse me, could be used to redefine residential use of property and commercial use of property in the context of rentals and short-term rentals. So I don't think we've heard the last on this issue, at least from my perspective. Thankfully, this did not pass, but we'll see what happens in this coming session. Next up are a couple bills that really stood no chance of passing, but I wanted to mention so you know what's out there. This bill was introduced, and there are actually two of them, one in the Senate, one in the House. One dealt with contractors and one dealt with subcontractors. But basically, these bills were drafted. It's as though a contractor sat down and said, what do I want out of not just life, but what do I want to force people to do? And this is like a dream list for contractors. It would have applied to multiple residential dwellings, including detached and site condominiums of more than 7 units. It would have applied to those of more than 7 units. Basically, it would have imposed pretty significant requirements if you wanted to object to an invoice that you got from a contractor. You required timely payment within 30 days, included 12% payment provisions for non-payment. And if you were going to dispute it, you were obligated to provide notice of a dispute within 10 days. So these were pretty, at least to me, these were pretty significant things that many contractors may like to put in their own terms and conditions, but are things that from the association standpoint, you may not want to see because it would make it difficult to object and contest invoices or work that you feel was less than what you expected. These didn't pass. We'll see if something like these come about down the line. If it's as harsh as this, if anything is introduced on the line as harsh as this one, I wouldn't really expect it to go anywhere, but it is something that was introduced. And it's this type of thing that we try to watch out for and indicate our objection, at least from the perspective of the LAC. The next one, kind of similar to the previous one, was HB 4825, called the Condominium Accounting Bill. Now, this is, to me, the disgruntled co-owner bill. To me, this just looked like there was a co-owner who didn't like the fact that they had to pay assessments and didn't like how their board, however it did it, went about conducting their business. And so there were a number of requirements that, if this had passed, would have really put significant hardship on boards as they move forward with financing, determining assessments, and coming up with their own budget. Just as an example, an audit report would have needed to have included a list of all delinquencies in excess of 6 months, mandated audits every 5 years, verified that all dues have been collected in accordance with percentage of ownership, even if it requires if it's done equally under the bylaws. These were some things that we thought were pretty significant and could have been a hardship on communities if it had passed. This, like the last bill, did not go anywhere, but in some level, a co-owner was able to get their legislative representative to introduce this. So in theory, it could have gotten traction. It didn't, but it's something that was introduced. The last one in this category deals with another effort to pursue a certification for emotional support animals. There was a similar effort that was done in the 2019-2020 session that was vetoed by Governor Whitmer because of concerns that it would violate the Fair Housing Act. This one was done from a different perspective. Instead of looking at the person making the request, this bill was targeted at the healthcare provider and imposed certain requirements on healthcare providers that would issue certificates for emotional support animals. And it would have set penalties for knowing violations of the act by those individuals, by those healthcare providers. This was an attempt to reintroduce the issue that had been vetoed back in the 2020-2021 session, but it did not pass. It has not been adopted. I do expect to see something like this again. It's now the second time there's been a pretty significant effort at it, and so we'll see what happens. We generally, from my perspective, I didn't really have any significant opposition to this. I think the effort that it made was all right. I think in practice, the bill itself could have been tweaked a little bit more, which is why it died out, but we'll see what happens down the line. All right, so we've taken a look at the some federal initiatives that have come and gone and that we may see again. We took a look at the bills that passed, and we took a look at some examples of bills that had been introduced that did not pass. There are a couple of initiatives that I expect to be pursued at the state level and really at the national level that boards and property managers should be aware of. You may see these, and so you should be aware of them and what their potential implication is. First up is an effort to correct an issue that came out of a case back in 2021. In February 2021, now a couple of years ago, there was an unpublished Court of Appeals decision called Channel View East. In essence, what Channel View East said is that, you know, if you impose fines, that's okay. If you're an association and you have the authority to fine, have at it, you can fine. But a fine is different than an assessment. And if you are going to foreclose a unit for non-payment of assessments, then, and if fines are included in the monetary amount that you are attempting to foreclose upon, then under your documents, that fine better be defined as an assessment, or else all it is a personal obligation to pay by the co-owner and not something that could be supported by foreclosure. As a result of that ruling, one of the things that we are attempting to work on is to try to get legislation passed that would amend two provisions of the Condominium Act that would specify, it would try to eliminate that distinction created in Channel View East and indicate that co-owners would be, if a co-owner is liable under the condominium documents for amounts. So if the co-owner owes the association money, then it would be considered an assessment subject to all available remedies. That's step one. The next thing that we were attempting to address, and which is in the proposed legislation, deals with the notice and hearing requirement for imposition of a fine. For those that are within a condominium, you know that there's a statutory requirement that deals with, if you're going to impose a fine, then you need to provide an opportunity for hearing. Now, some attorneys interpret this differently. We interpret this language, at least under the current version of the Act, to require that the board hold a hearing before imposing a fine. Now, what we are trying to do with this legislative, with this bill, would be to try to amend that requirement so that it is only the opportunity for a hearing that is required, so that the board doesn't need to go through the sort of motion of holding a hearing if the owner has no intention of showing up or never requests the hearing. So those are two fixes that I expect to see in the 23-24 session. One being to address the issues set forth in Channelview East to include fines as being considered assessments, and the other to clarify the meaning of notice and hearing contained in the Condominium Act. The next one, which is one of the two big ones, is an effort to correct the Marketable Record Title Act. Now, I already covered in the session dealing, or the portion dealing with bills that passed, the benefits, potential benefits to HB 6370, the bill that passed in 2022 that benefits utility companies and conservation easements. And there is language in that act that could potentially benefit community associations. However, we don't think that that's enough from our perspective. We would like to see a specific reference in the Marketable Record Title Act that protects community associations, both condominium associations and HOAs, from the potential negative impact of the Marketable Record Title Act. Just to give you an example of the things that we would like to see, we would like this bill, we would like language to be added to the Marketable Record Title Act that specifies that recorded master deeds and recorded declarations or deed restrictions, which are administered by nonprofit community associations, are excluded from the Marketable Record Title Act. We have not been successful in finding a home yet for that language, but it's something that we intend to pursue in 23 and 24. And so if you see efforts along those lines, we would encourage you to try to support it. Basically, the reason is that if it comes to pass that there are communities with deed restrictions that have deed restrictions that are older than 40 years, the risk is that either those deed restrictions will be eliminated altogether, thereby eliminating the ability of the community association to administer the community in the first place, or it's possible that you could have communities with some neighbors who are bound by the restrictions and other neighbors who are not, depending upon how long ago they bought their property and depending upon whether or not the deed restrictions are within their chain of title. So this is an issue of significant importance, and we expect to see another effort to try to address it in 23 and 24. And the last issue that I wanted to cover on this issue at least deals with reserve studies. The state of Michigan does not have a present requirement at a statutory level, at the state level, to have reserve studies be conducted. Michigan law, however, does require that there be adequate reserve funds set aside for condominium associations that are equal to at least 10% of the annual budget. I mentioned earlier that in 2021, there was a condominium, a significant portion of which collapsed. The reason it collapsed is there's a number of factors, but the association had not been able to get the assessments collected that would have been sufficient to make certain repairs. And as a result of the inability to collect those funds, repairs were not made, and the condominium collapsed, and 46 people died. As a result of that, we saw some of the federal bills that were introduced dealing with improving the ability and efficiency with which both owners and associations could get access to financing in order to address these issues. And then also the Disaster Relief Act, which was intended to address to a certain extent getting access to FEMA funds in the event of a disaster. Coming out of that, both at the national level and at the statewide level, there are significant efforts to change the state's view of reserve studies and reserve funding. Specifically, as it relates to Michigan, what we expect to see is that at least to the condominiums that would fall within the category and being covered by this, we expect legislation coming down the pike to require reserve studies to be conducted. That's not presently required, but we do expect that to occur down the line. And we also expect that there be some level of a connection between the reserve studies and the board's consideration of the budget and consideration of the reserve funding. And we also expect some a revised approach with respect to the obligation of the boards to inform communities about the existence of a reserve study. And just to give those on the call an idea about what a reserve study is, a reserve study is intended to be a funding mechanism where a third party comes in and a third party comes in and evaluates the repair obligations and the common elements of a community and attempts to determine, for the benefit of the board, the long-term costs to repair. So it's kind of like a funding plan. What is the life expectancy first, what are the common elements that need repair? What are the capital improvements that need repair? What is the life expectancy of those items? And then what would be the expected cost to make those repairs when the time comes? All of that information is collected and turned into a reserve study, the purpose of which is to try to give the board a handle on the funding requirements to maintain adequate reserves. So the idea here is that at a statutory level and in many of the states, to impose certain requirements to have these done, not necessarily to mandate that funding be at a certain level, but that the board and the community have access to the information necessary in order to be able to determine how much really is needed to be able to finance the needed repairs, in order to get an accurate depiction of what amount of funds would be necessary to keep the building, to keep the community in the condition it is to keep going into the future and make sure that repair and replacement can be made. So reserve studies, reserve funding, I do expect to see down the line. Some states have taken some pretty aggressive approaches, even requiring changes with respect to building inspections and structural building inspections. And just to back up a little bit, a reserve study is not a structural engineering report, that's something different. But a reserve study would be something that is intended to help with funding. So that has not yet been introduced in the state of Michigan. There are versions of it that have been introduced already in Illinois, Maryland, and Florida. And it's passed in Florida. I don't believe Maryland's has passed, but it's popping up in a number of states in order to address, in essence, what's viewed as the aging infrastructure of buildings in order to protect those that live within them. So we'll see what happens with that down the line. All right. So those are the categories, and those are things that I wanted to cover. We went through the federal legislation and the federal initiatives, the state legislation that passed, some state legislation that did not pass that we may see again, and then some state initiatives that I expect to see down the line, namely the fines language, the MRTA, and the reserve study issues, which I expect to see down the line. So with that, I'd like to open it up to questions. If you have it, if anybody on the call has questions, feel free to either drop it in chat or, subject to see how this goes. If you want to unmute yourself, go ahead and voice your question that way too.
Well, I always have a question.
Okay, that's great. Go ahead.
You were referring to HB 4416, removing restrictions about race, color, religion, sex, etc. What about criminals, people that have had past criminal records?
Well, that would be different. That wouldn't really be, at least I wouldn't expect that to fall within the scope of interest to a community association. I think what you're talking about is expungement of a criminal record, basically wiping the slate clean. What this bill, which HB 4416 is intended to do, is for decades, there was language contained in deed restrictions that were recorded in the chain of title that would specifically say individuals of a certain ethnicity or a certain race or a certain religion were prohibited from living in a certain area.
They really said that?
Oh, yes. Yep.
Oh.
And so for many communities, that language still exists. If your community documents go back to the 30s and 40s, that language is still there. And you can see how it can be offensive if you are within a group that you have to live with a set of restrictions that contains language that is directed at you. Now, it's unenforceable, but what this language is intended to do is intended to give a board the power to actually discharge that by recording a discharge form, to discharge that from the language of the documents itself.
Okay.
At least with respect to individuals with criminal convictions. I don't expect to see anything like that because they would not fit within the protected category protected by the Fair Housing Act. And ordinarily, I would expect that those efforts would be directed towards expungement, which would be done through the court system.
Okay, thank you.
Yep. All right, anybody else?
There's an item in chat.
Oh, thank you. There's a couple, there's a handful, thanks. All right. Yes, it'll be available on YouTube. Okay. What's the difference between a reserve study and an engineering report or a structural engineer report? So a reserve study is a fairly cursory assessment of the things that will need repair and their expected life expectancy, and then the cost to repair them, at least as of the date of the reserve study. Reserve studies need to be updated. To be effective, they should be updated every 3 to 5 years, both from a physical standpoint, meaning that you're identifying issues and seeing what needs repair, but also from a monetary standpoint to make sure that the cost that you expect to fix something is the true cost at that point in time. But at least with respect to determining the condition of the building, it's a fairly cursory evaluation. It still exists, but it's relatively cursory. A structural engineer's report will go into detail about the condition of the building and the condition of those items that the engineer has been asked to look at. There really is no substitute, especially if you're in a tower building or you have multiple stories. There's no substitute for an assessment of both the foundation and the structural condition of the building. So a structural engineer's report is going to be much more in depth and give a lot more detail about what needs to be done. It will not be as focused on the cost to do that. It will just tell you what the problems are and what needs to be done. Okay,
Matt, good response.
Yep, no problem. Okay, so there's a question from Mary. The private road and waterway is not eligible for FEMA. Okay, so FEMA, the FEMA issue.
Oh, I had that marked. Yeah, good question.
Okay, so FEMA this was each of the 3 bills at the federal level, these were intended to, from a certain perspective, make it easier for associations and residents within associations to have access to funds and access to financing when needed for certain things. The first 2 categories, the Safer Condos Act and the Critical Condos Repair Act, those dealt with a need for repair of the building itself or a special assessment being imposed for necessary building repairs. The Disaster Assistance Equity Act is different. From FEMA's standpoint, FEMA has a public assistance program that reimburses costs to public bodies for disaster debris removal from public roads and public waterways.
Right.
Private roads and waterways are not eligible for that type of reimbursement. Now, at a certain level, you first need a FEMA disaster that would qualify for FEMA to otherwise be applicable. But assuming that a disaster applied where FEMA was applicable, the purpose of this was to at least create some level of equity and recognize
Yeah.
private communities have similar costs with the road repair that can take place and can be necessary in the case of a disaster. And so it's an effort to try to make those costs reimbursable, which they're presently not. So, we'll see if it gets reintroduced in the 23-24 session, but it did not pass. And at least as of now, that distinction still exists.
Thank you.
No problem. So, okay, so there's a question. How can we as board members support our effort to amend our MRTA? One is, once we find a home for it, meaning we have a legislator that is willing to take it on, I would support that bill when you see the opportunity to do so. The LAC intends to have a session at the end of February where we're intending to meet with legislatures to go over some of our issues. And what we will most likely be doing is circulating information to CIA members and to clients, really, at least through our website, giving them ways to express support by providing information to the legislators. So to the extent there's an ask on this particular thing, it would be to look out for information on this. If you see emails soliciting your support for MRTA amendments, respond to them. And we expect to have sort of template language that could be used and directed towards your legislatures to make them aware of the issue. So I would keep out for things like that and respond when you see the opportunity to do so. Michael Lamping, thanks for putting that in. They really existed and they're still out there. How much lobbying is being undertaken by VRBO and Airbnb? I'm assuming Airbnb is implied in that. They were kind of behind the scenes, but my understanding it was pretty significant, along with the realtors lobby the builders lobby. Basically, there's an overarching goal to eliminate the use restrictions to make it easier and create the concept is that, at least from their perspective, you're creating a bigger pool of potential buyers by making it eligible for purchase, making units and land eligible for purchase by investors for purposes of use of short-term rentals. So that's the thinking behind those that support the short-term rental type bills, which is inconsistent with some of the views and some of the approaches taken by residential communities, but not all. There are a fair number of communities that support and engage in short-term rentals. But if the question is who's generally behind the lobbying addressing the support of HB 4722, it does tend to be short-term rental proponents such as VRBO, Airbnb, Realtor Lobby, and the developers lobby. All right, so those were the questions in chat. I'll take others too. I mean, we've got more time, so I'm happy to address anything. Here's one on, okay, so what type of regulations can the board apply to residents with emotional support animals? So this is generally going to be considered an analysis under the Fair Housing Act. There's really two kind of levels of analysis here. One level of analysis deals with when must we allow an emotional support animal? And that's going to be under kind of a traditional analysis under your reasonable accommodation. So you have a co-owner who has come to you and asked for a reasonable accommodation. You may have rules that prohibit pets or limit animals or prohibit types of animals or require approval. And you have somebody that comes to you and says, notwithstanding those requirements, I'd like my emotional support animal that otherwise violates the rules, but you need to give me a reasonable accommodation in order to address my issue. That's going to be your FHA analysis as to whether to do that. Is the request supported? Is there a need for the animal? Is there a disability, identified disability that would support a need for the animal? And depending upon the type of animal, has the type of animal that's being requested is the need also supported by the individual? There are certain FHA requirements that guide how you can ask those questions and how you can address it. But they're, in my view, at least, are generally guided by the Fair Housing Act requirements. Now, once they're in, what type of restrictions can you apply to that animal?
Yeah.
And can you require that animal to generally come into compliance with any other animal? In large part, that should be the case. Now, you know, do they need to be leashed? Do they need to pick up after them? Those types of things you should expect to be able to apply. However, if there are requirements that cannot be met by that animal and they are well supported by the individual as to why that animal needs an accommodation on that issue, that would need to be analyzed on a case-by-case basis. And an example on that would be a fence is the one that I'm kind of thinking of. Is you may have a restriction that prohibits fences, and you have somebody that comes to you with a dog and they say, I need this dog, I have to have this dog, and my dog needs the fence. It's probably not just a carte blanche across the board. No, it would need to be evaluated. It still may come to pass that you end up rejecting the fence, but depending upon how it's presented, you may need to evaluate it and determine whether or not the fence itself is well supported. And I do expect there to be another effort at that. I mean, I think the emotional support animal concept is sort of reaching an equilibrium to a certain extent as people kind of understand the contours of the law on it, but there's still abuse in the area. And so I do expect another run at modifying that, modifying the requirements to give greater clarity.
No, people know.
All right. So I've got, I'm probably one of them, but I still have 28 people in the chat. So if any of the 28 have a question, feel free to have at it. We do monthly call-ins, and so some of you on the call may participate in those. And so sometimes there's gaps when people ask questions, but feel free to raise it. All right, so I'll have a.
Are you saying we can ask a question about anything? Sort of semi, even though it doesn't refer to these laws and regulations?
Probably not, but go ahead. I'll hear it and then I'll say yes or no.
Okay, I'm just concerned. We're zoned R1 in our area, and we have numerous residents who kind of run businesses out of their units, and we've overlooked it. But I guess my concern is, how do we handle this? What do we do? Any ideas?
Well, hi, Mary, first. And I don't recall exactly what your documents say about it, but
we're zoned R1. It's zoned as a residence only.
Yep, you'll want to take a look at your bylaws to see what the use restrictions are. And
that's what it says. It says residential only.
Yep. That's probably an offline question that we'll need to go over and not put into a into this. I'm sorry, Mary.
Okay, that's fine. Just curious.
Yep. Okay, does the Michigan statute allow co-owners to change the bylaws to give co-owners veto power of budget and contract approvals? In the non-condominium setting, in an HOA world, depending upon how the declaration is phrased, which is done entirely by contract, there's no Michigan law that would prohibit validly adopted restrictions on board spending, and those often exist. In a condominium setting, there are certain provisions regarding the ability to budget, which would must be followed. And so if there were limitations on the ability of the board to fund necessary repairs and replacement or to determine reserves, I expect that could run into potential conflict with the Condominium Act on that issue. However, we do see restrictions that are intended to sort of hamstring boards as to raising assessments or creating budgets or and imposing special assessments. The biggest power really right now that exists in Michigan on this issue, which is not statutory, but is more of a practice, is that many communities have restrictions on a board's ability to adopt special assessments for additions to common elements and require co-owner approval. Most communities do not require co-owner approval for assessments that are needed, even additional assessments that are needed for repair and replacement. That's uncommon. And the tendency right now is, because of Surfside, to take a pretty close look at restrictions that would limit a board's power or ability to fund necessary repairs, and to consider whether those should be allowed or not. All right, well, I've got just a couple minutes after 7. Door is still open on questions, but I'm probably gonna call it in a couple minutes.
I'm done.
All right, so I know the presentation is going to be put online with respect to getting a PDF of the PowerPoint. We can make that available. Please either email me or Bridget, our marketing director, and we can make sure that you get a PDF copy. So thank you all for joining. Hopefully it was helpful, and hopefully you're watching this from your home and not out in the snow, at least where I am. All right, have a good night, everybody.
No.